So you've probably noticed that I am not where I usually am when I speak with you, which is from my desk, and there's a very good reason for that. Today I was running a bail application in the local court, and I thought instead of just talking with you from my desk and showing you all the documents, why not bring you with me? So at the end of this drive, my promise to you is that you will know what bail is, why it exists, its purpose, how it works, and the kind of preparation that actually goes into running a bail application. So stick with me, enjoy the drive, and let's figure out how bail works. So what is bail and what is its purpose? Well, they're actually really simple answers. Bail is what's called conditional liberty. So it means that there is some sort of identified risk, which we'll go through, that the court has identified, that the prosecution has put forward, and on that basis they say that, well, this person shouldn't be allowed in the community. Bail is the imposition of conditions so that that risk is no longer unacceptable. The risk may still exist, but the risk will be acceptable. But the important thing to remember is that bail is not designed to be a punishment. Bail is designed to be a balancing act between the risks that may exist against the defendant's presumption of innocence and right to be at liberty. Now, how the court balances that is what we're going to get into next. Across Australia, bail is almost formulaic. There's definitely an element of discretion, there's definitely an element of weighing the potential evidence, but it's all governed by the Bail Act, whether that be the Bail Act of New South Wales, Victoria, Western Australia, whatever. So if you want to know how the structure works, it's actually really neatly contained in the Act itself. They even include tables. But just because it's contained in the Act and just because there's a table doesn't mean it's straightforward or simple. Bail is actually one of those areas that can be very difficult to navigate because you're constantly balancing a knife's edge. And as a lawyer, the last thing you want to do is try and tell the court there are no risks, because they're just not going to listen to that. So what you need to do is you need to identify the risks that are likely to be brought up, and the conditions that you say change that from an unacceptable risk to an acceptable one. What are the 4 unacceptable risks? Remember, there are only 4 of them, and they're these. Failure to appear, meaning that there's a flight risk or somebody's likely to flee the jurisdiction, or that there's an unacceptable risk that they will flee the jurisdiction. Commit a serious offence. This is a big one. So is it likely that the person who is currently in jail on the bail application, not yet released, is it likely that if they are released, they are going to commit more offences, and are they going to be serious offences? The third is endangering the safety of the victims or the community. Now, I know that they're not victims yet because nothing's been proven, but that's what the court's looking at. If this person is released, is there an unacceptable risk that the community or that the victims in this matter, the alleged victims, are going to have their safety endangered? And the fourth one is interference with witnesses. Now that one's a bit tricky because often if you're looking at things like domestic violence allegations, it really sort of comes to under the third one, the endangering the alleged victims. But interference with witnesses is really more looking at, is this person going to try and interfere with the natural order of things? Are they going to try and get witnesses to change their evidence? Are they potentially going to try and delete or destroy evidence? So that's something that really needs to be taken into account. But it's not just whether there's a risk, it's whether the risk is unacceptable. And how that's established is really in 2 stages. So what happens? The defence ordinarily will bring a release application. That's what they're technically called, even though everybody refers to them as bail applications. And they will say that we're seeking the release of Mr. X, Mr. Smith. What will happen then is the prosecution, it's then their turn, and they get to identify what they say the unacceptable risks are, which of the 4. And often, at least if it's a good prosecutor, they're not going to hit all 4, because it's very rare for all 4 to be legitimate, unacceptable risks. At least from when I was a prosecutor, what I found to be most helpful, and certainly what would have me listen to, is being able to identify the actual unacceptable risks, not just throwing everything in a shotgun approach. So here's how the prosecution comes to what they say the unacceptable risks are. I'll go through all 4. So starting with the first, we have the flight risk, the failure to appear risk. Now that's going to come up if the accused person, the person in custody, has a lengthy history of not appearing or a lengthy history of bench warrants or disappearing.
Okay.
That's very, very difficult to get over. It's not impossible to get over, but it's very difficult to get over, and for good reason. When somebody is charged, irrespective of whether or not they are eventually proven to have done the alleged acts, it's really important that for the public, for the community, for the rule of law, that we go through this process and that we're able to have them appropriately dealt with, even if that means eventually a finding of not guilty. There's another big one, and it usually applies to when defendants, or the accused, or the person in custody, however you want to refer to them, has another passport, or they're here on a visa or on holiday. Obviously, there is a risk, especially if the allegations are serious, that that person is going to flee the jurisdiction. And then, yes, it may be possible to get them back through extradition, but it's much easier to just avoid that altogether. The second identifiable risk, committing further offences. Again, we're kind of looking at past conduct and future risk. So if there's a long history of serious offending, if there's a lot of what's called recidivism, where even on a finding of guilt and after punishment, or after rehabilitation, or whatever the outcome is, that person still commits the offending, that's not very helpful for them if they're trying to get bail, because the court can look at the history and they can say, well, you've committed 10 of these offences in the last, I don't know, let's say 2 years. Why on earth would the court have confidence that you're not going to commit another one?
Because I like it. Hell, I love it. I'm just itching. I'm itching to do it again.
The third identifiable risk is endangering the safety of the victims, alleged victims, or the community. That's a really big one, and it's a really important one, and it's usually the one people get quite upset about when they see people getting bail, and the public believes, at least according to the pub test, that there is a real risk. It's especially common with domestic violence matters. Guys, seriously, if the relationship isn't working, just leave. And there's absolutely no excuse for domestic violence. None. At all. I've seen the horrific outcomes, and I've seen the effect it has, not just on, for example, the partner, but the children, who may not even be directly affected by it, but are witnesses to it. But again, it's really important to remember that these are still allegations at this point. Nothing has been proven. So we're looking at the unacceptable risk when we talk about that, and we'll get to how that risk can be mitigated. The fourth one is interfering with evidence. That one's relatively straightforward, although depending on the factors that come into it, the individual facts of that matter, it can actually be the undoing of a bail application.
Family.
So you're saying shred the evidence?
No, that's illegal. The prosecution is entitled to that evidence. Without it, they don't have a case.
So you're saying shred the evidence?
So we've gone through how the prosecution can identify the risks and what each of those risks ordinarily looks like when it comes to the potential conduct. Now it's time to go through what the defense can do, what the person in custody can do to say, well, yes, I accept that there's a risk, but there are conditions that can be imposed on my liberty if I'm released that make that risk acceptable, that lessen the risk to a standard which doesn't require that person to be in custody. Now we'll go through the conditions that can bring each of those identifiable unacceptable risks to an acceptable level, dealing first with failure to appear, the flight risk. So what the conditions are that are imposed when you're talking about bringing the unacceptable risk of flight down to an acceptable risk. If somebody doesn't have a passport, it can be things like reporting to the local police station, let's say 3 through to 7 days a week, once, and at the highest I've seen 2 times a day. Now that's really helpful because it shows that if they're regularly reporting and they miss one, apart from that being a breach of bail, which we'll deal with, if they miss one, that means that the police are immediately aware of it. If you're talking about people with international passports, dual citizenship, or they've been travelling here and they're alleged to have committed an offence while in Australia, that's another big risk for obvious reasons. Now, usually what will happen is that person will be required to surrender their passport, and often there will be a condition imposed that they're not to approach any international point of departure. And you can kind of see how that reduces it from an obvious risk, but an unacceptable risk, because if that risk is made good, they flee the jurisdiction. Then you have to go through the nightmare of extradition applications, and it's simply just not worth it. And often for a lot of lower offences, people just won't, there's really no grounds to make an extradition application. Dealing with the second unacceptable risk that can be identified, committing further offences. This one can be a little bit more difficult. Again, if it's something like home invasions or break-enter and steals and they're occurring at night, often you'll find a curfew condition imposed. So people have to be at their residence between the hours of, let's say, 7 p.m. and 5 a.m., depending on work conditions. Now that reduces the risk of that specific type of offence. If it's a different kind of offence, let's say that every time this person gets drunk or on the gear, they end up committing violent offences in public, it can be exclusions from those places, and there can be conditions imposed where that person's not allowed to drink or take prohibited drugs. That's a really important one, because the other thing that usually attaches to that is what's called an enforcement condition. And an enforcement condition allows police to go to that person's residence during the curfew, check that they're there. The other thing that they can do is they can drug or alcohol test to make sure that they are not, in fact, under the influence of drugs or alcohol. It can get very personal, but again, would you rather have the inconvenience and be outside than have the inconvenience and be inside? The third one is far more complicated, because we're talking about the potential risk or the unacceptable risk to the safety of the community and the alleged victim. Again, this is very common when it comes to things like drink driving, if somebody's been caught drink driving multiple times, or if there's a domestic violence allegation, and especially in circumstances where it's against the same person. That's hard, and that's a very difficult thing to weigh up. Now, the unacceptable risk is naturally really very high, because we're no longer talking about the process not being able to take effect, for example with failure to appear. We're no longer talking about potential offences without perhaps any real identifiable victim at that point, because it's all theoretical. Now we're talking about real physical and safety and emotional impacts on the community and potentially on the person who's alleged to be the victim. So often, if it's a personal issue, if it's against one individual, an identifiable individual, those conditions will be things like a place exclusion or a non-contact provision. Often, if there's an ADVO in place, it will be things like to comply with the ADVO. Doesn't necessarily mean that it makes the unacceptable risk acceptable, but it's quite common. If you're talking about things like placing the community in danger, people who steal cars and drive 200 kilometers an hour through residential streets, that's different. So again, we may be talking about a curfew. Ankle monitors have largely gone out of style, and something a lot of people don't know is that the person who's on bail actually has to pay for that. So often that's something that can't be done. It also doesn't necessarily provide much protection, because yes, it notifies police if the ankle monitor is cut off, but it may not always be that easy to get there. Cars may be tied up with a big accident or a public order issue. By the time that happens and police get to the location the ankle monitor was cut off, it's usually too late. Ankle monitors, then generally speaking, they're just not a good idea to propose. There are some circumstances in which you kind of have to, but I wouldn't. So if we're talking about somebody who's got a slew of driving offences and putting the community at risk, and that is a risk, if you've ever seen a big car crash at speed, it's horrific, really horrific, often fatal. So the risk is very high. So you can impose things, again, like a curfew, or you can impose things like not to be in the driver's seat of a vehicle. Which brings us to the fourth, which is the unacceptable risk of interfering with witnesses. Now, I said before that this can be quite difficult, and it can be. Talking about things like interfering with witnesses, often you're looking at things like not having access to computers, not having access to mobile phones, things like not contacting any witnesses. I mean, that's a big one. So let's say you get bail. Let's say that you've gone through this, or your lawyer's gone through this. They pointed to the cases, they pointed to the facts, they pointed to the conditions and how they reduce those unacceptable risks to acceptable ones. What happens if you breach bail? What happens if you contravene the court's orders? Doesn't always mean that you're not going to get bail again, especially if it's a technical breach or if you have a reason. So sometimes if you can't report because you've, been in hospital or you've been sick, you need a doctor's certificate for that, by the way. Get one. They're not that hard to get. But it doesn't take away from the fact that there are a couple of issues that arise. A, you've been arrested, which means that often these arrests occur in the afternoon. You're not going to get before a court. God forbid they happen on a Friday afternoon. You will be in custody. You will be bail refused. If there's a bench warrant because of some identifiable breach, you're definitely getting bail refused. And then you have to wait until you can get in front of the court. That's not a great place to be. And the real risk is that even if they are technical breaches, if they were somehow avoidable, and you don't have any evidence to show that there's a good reason why you didn't avoid the breach, why you didn't comply, makes it really, really tricky. And it's not just about being arrested for that breach bail offence. You can actually be sentenced to periods of imprisonment if the breach is serious, especially if the breach is by violence. Long story short, if you get bail, abide by the conditions. You can make an application to vary them. There has to be a reason for it. Maybe it's been, 6 weeks since the initial bail application and it was successful. Maybe it's the case that your hearing date won't occur until 8, 9, 10 months down the track, maybe even longer. They're good reasons that you can point to and say, well, we need to vary some of these conditions because now it's no longer acceptable in the sense of it not being overly difficult to comply with. What happens if you don't get bail? Well, if you don't get bail, it's generally speaking pretty simple. If it's your first time applying and you don't get bail, you go back inside. Well, you never really get out. You can make a second application. There's a section, at least in the New South Wales Bail Act, and I'm sure it's in the others, that says that you can't just keep making bail applications. So if you want to make a second application, what you have to do is you have to show the court that it's a different set of circumstances, or that there's material that can be put before the court that wasn't available the first time. Now that's enough to get you over the hurdle of making the second application. It's not necessarily enough to get you over the actual application itself. Just a real quick interruption, because I forgot to mention anything about this while I was recording the video, and I thought if I don't do it now, I'll never do it. If you want to see other content, if you want to hear other stories, if you like this kind of video where I take you with me, or if you want to know more about my time in the police, this channel exists purely for you guys. So let me know. I read all the comments, I am interested, and I just want to make sure that I'm giving you the most value that I can. So get involved in the community posts, let me know what you want to say, let's get back into the bail. If they are really serious offences, often they will come under what is called a show cause offence. Now that changes things quite dramatically. What happens is, instead of the prosecution going first and saying, well, we say that there are these unacceptable risks, and then the defence goes and they say, well, we say that there are risks, but they're acceptable risks, or they can be mitigated by the conditions. What will happen is the defence goes first, and it's actually a very, very difficult test to get over. Show cause means that the default position of you should be on liberty unless there are good reasons not to be is inverted. It means that the defence now has to prove that the person's being in custody isn't justified. And it's a very high bar to get over. It's not always easy. I've had cases where the risks are easily mitigated, very, very easily mitigated, because the risks aren't that high. For example, they haven't had any prior offending. But we can't get over show cause. And that's a problem, because even though the person may not pose that much of a risk to society, that imposition of the show cause hurdle, the first test, and then dealt with separately, means that you never get to show the court that these conditions can easily be imposed to reduce the risk to an acceptable level, or sometimes to mitigate it almost completely. And then there are the granddaddy of offences. These are the ones that carry life, the very, very serious ones. Not just those ones, there are other offences as well, but that's the kind of offence we're talking about. Even if you get over show cause and you can show the court that the risks are not unacceptable, that there are conditions, however extreme they might be, that reduce that risk to an acceptable level, what will happen is the prosecution can hand up what's called a bail stay certificate. And that's usually signed by an inspector or above. And that means that where the court says, well, we accept that this is a serious allegation, but we also accept that the risks can be mitigated, that they can be reduced. The prosecution can basically uno reverso it and say, yeah, it doesn't matter, we're staying the decision. Now, that may surprise you, because typically think that the court can't be overruled. The local court absolutely can be. And it happens. I have used them myself when I was prosecuting. They were for very serious offences. I didn't feel bad about using the bail stay certificate, but it still doesn't quite sit right with you, because if the court has found that, these risks can be mitigated, and often they're quite cautious when it comes to that sort of thing, who is the prosecution to say that they're wrong? It just seems at odds with everything else about the criminal legal system. But again, in saying that, I'm sure that it makes people who are the victims, even if it may not yet be proven, of very serious offences, feel a bit better knowing that they're certainly not going to get out immediately. So perhaps there's some practical utility to it where those people can find a way to cut contact, move, whatever it is that they need to do. Preparation that goes into these applications should be extensive. Often you'll see people running these applications on the fly. I don't love that. It doesn't make a lot of sense to me. I mean, if you're dealing with somebody's liberty, it's not your life, for one thing, it's their life. So you need to treat it with the proper respect. And it takes time. It takes time to do these things properly. It takes time to collect the evidence. It takes time to be able to clearly map out how the conditions might mitigate the risks that are identified. Because you don't always know what the identified risks are, so you need to prepare for all of them. In saying that, when I was prosecuting, I almost had no time for any bail application. You would just get them if you were in the list, and you would just have to deal with them as they come. Now, you do a lot of them, and when I say a lot, I mean a lot. But at the same point in time, skills are great. You need skills, and they can make a difference, but nothing quite overturns a strong body of evidence. It's not fair, but it's just the reality of the system as it exists. The defence, hopefully, are going to put a lot of time into these applications. Often, especially at the local court level, which is where all bail applications start, including, Ben Roberts Smith, life offences, murder charges, the really nasty ones that I don't really want to bring up, and I'm sure you don't want me to talk about either. They all start in the local court. So it can be quite difficult when the defence has sometimes weeks to prepare for these applications, and the prosecution just gets them the day off. But it's the way it is. Different at the Supreme Court level, I'd hope. I've never been a prosecutor at the Supreme Court, but I would hope they have more time and they put more preparation into it. So hopefully that has answered a lot of your questions on bail. Often you will see the headlines and there will be no real detail as to how we got there, what the conditions were, all the rest of it. I find whenever there's a headline, whether it's in the paper or online or on the news, it's not their fault, because I know that they need to grab attention to get people to read the article. I get that. But it's really, really unhelpful when you see headlines like, baby murderer gets bail. There might be good reasons for that. It may be the case that there are no witnesses. It may be the case that the prosecution's evidence sucks. Or it may be the case that there's no real risk of reoffending, or that there are genuine conditions that can be imposed to prevent that risk, or to at least mitigate it. So my hope is that this has explained a lot of this, and if that you ever have anyone in your life that likes to fly off the wall, and that includes me, I love a good rant, even though I don't put them on here, now you can point to something. You can say, no, this is how it works. My genuine hope for this channel is that by doing this, I can show people who want to be involved that your opinion matters and that it will be heard, even though most people just don't believe it. So let me know if you do. I get emails, I get direct messages from people telling me that they've done it, and it genuinely makes my day. As always, I appreciate your attention. You could be spending this on anything, and you've chosen to spend it with me, and that means a lot. None of you have massive amounts of free time. You all have real world responsibilities. You all have things going on in your life. So, thank you. I'm James Glissan, and I will see you in the next one.